All right, good afternoon, everyone.
Good afternoon.
Okay, we are here in the case of the state of Florida versus Katherine Magbanua. It is case 2016 CF 3036 and 2018 CF 497. And let me just check and make sure that we have all of our counsel present. Good afternoon, Mr. DeCoste. And Ms. Kwas, I do see you too. Also, good afternoon, Ms. Kappelman.
Good afternoon.
Good afternoon, Ms. Kappelman. And I see that Ms. Dugan is also on. So we have all the counsel for the parties present. I don't see the Leon County Jail on, so I don't believe that Ms. Magbanua is going to be present here for this motion to continue. I know I had mentioned that for the other substantive motions, I would make sure that she is going to be present, but I don't see her on the video today. So just for the record, Mr. DeCoste, for just this joint motion to continue that we're going to address today, do you waive her appearance here today?
Yes, Your Honor, and I believe that Ms. Kwas is okay with that as well, too.
Ms.
Your
Kwas?
Honor, for the record, I was able to speak to Ms. Magbanua earlier today, and I told her there was a chance she may not have been present, and it's fine. She'll follow up with me later this evening.
All right, thank you.
You're welcome,
Okay.
Judge.
We're here on this joint motion, and there was also a supplement to that filed on behalf of the defendant. And so it looks like defense was the author of the motion itself. So I'll go to them first for the argument. And so who would like to present argument on this first?
I'll handle the argument, Your Honor.
Okay.
And the core of the argument is in the motion. The major one is the joint motion to continue with the other issues that we raise in the supplement. I do believe that I've addressed everything in the joint motion to continue with respect to the witness McElveen. If Your Honor wants to only address that issue first and then get to the other ones.
That's the only issue that I want to address.
So with respect to Mr. McElveen, and as described in the deposition, we recently took his deposition, and during that deposition, we learned a lot of things that are going on right now. More importantly, we received his most recent audio enhancement 90 minutes before the deposition. That was done, and I believe that Your Honor has the transcript and perhaps has read the transcript from the deposition.
I have read it.
Okay, so he was given a deadline before the deposition of about 90 minutes before to get over to us what it was that he was working on and where he was at. Understanding this is happening at the last minute, there are still things that myself and Ms. Kwas need to do for Ms. Magbanua with respect to Mr. McElveen, but I do believe my argument is fully in the motion.
Okay. So nothing else to add other than what's in your motion, which I have reviewed, and I've reviewed the attachments to it. Ms. Kappelman?
Yes, Your Honor. Mr. DeCoste correctly stated my position in his motion, which is that I do not object to the continuance on that ground regarding the audio expert, Mr. McElveen. He had been retained to do some work on the case. He decided he needed to do some additional work on the case in order to give me his best effort on this audio clarification. I agreed to that. I did not give him a deadline of prior to the deposition. In fact, it was my understanding that we would not have a reasonable expectation of receiving anything from him prior to the deposition, but he did provide that.
Why not? Why not? I mean, we discussed Mr. McElveen at our December 9th case management, and he was one that was an exception to the order that I set forth, requiring that all discovery be completed by December 2nd, and that's what I expected. And he was an exception to that his deposition, for whatever reason, wasn't going to be taken until January 21st. I permitted that, but I expected all work to be done and that he could give his deposition at that time as a fully informed witness so that we could move forward with this trial. And so why don't we have him prepared? I mean, we have a situation here based on his testimony in his deposition that After we discussed him at the case management on December 9th, then prior to his deposition on January 21st, the audio recordings weren't even given to him until January 5th, which is almost a month after that. And then he doesn't get, I mean, that's when he was contacted. And then he doesn't even get the original audios until a week before his deposition on January 20th. So this is a witness that we had talked about back on December 9th. That why?
Judge, just to clarify a couple things that you said, I'm having a little bit of a hard time hearing you because of this. It just says iPhone on the screen. I don't know who that is, but they could, thank you. Mr. McElveen was retained. He was provided with working copies of the recording. He requested additional information. Can you tell me what it was called?
He had to go back to Miami.
The additional information, different copies of the recording is what was provided on the 9th, the date that you're referencing.
Well, that's not what he
always had copies. That's not what delayed him. It's just taken him this long to do his work. After doing his initial analysis, he decided he needed to go to Miami, to go to the building where this recording took place, to take testing of the reflections of the way the voices move off the walls. And, you know, this thing has just taken longer than the state anticipated. I was well aware of your deadline and knew that we were going to exceed it. I just had low expectations for what was going to come of it. Now that I'm in a posture where I think something productive might come of it, I do want to use the item. I'm aware that we're past your deadline. I'm aware that it's prejudicial to the defense to not have this item in hand, but I can't make him produce it any quicker than he can produce it.
Well, that's where I think you're wrong, because I think it could have been given to him a lot sooner than what was provided. Because according to his deposition, he didn't even get these audios until just right before he was going to take his deposition. And of course, he doesn't have time to work on it. So it's an unreasonable delay, regardless of why he was delayed. And I mean, we've made every effort to try to get this case to trial. And now here again, we're going to be put into a position where the court has to delay it again. And we've sent out juror summons again. And it just is unreasonable to this court. And but I don't have any choice. Based on your agreement, based on the fact that both of you think that there's something productive, either on behalf of either one of your clients, that is going to come from this enhancement, and that he has the opinion that there will be some type of enhancement, although he doesn't know how much. I don't have any option but to continue the trial and until that is complete. He doesn't know when that's going to be complete. So what's our best estimate as to that?
The estimate that he provided regarding when his finished product would be complete was going to put us somewhere toward the end of the first week of trial or the beginning of the second week of trial. So he said 3 to 5 weeks, and that was a week ago.
All right, so through February basically is when he's going to need, and then Mr. DeCoste, then you're going to need additional time to take depositions. We have 2 other witnesses now potentially. I don't know if they're witnesses, but 2 other names that have now popped up that are FBI agents, and I don't know if you're going to need to look into that. So how much time are you going to need after that in order to complete your discovery?
Your Honor, if I could list some of the things that we're needing to do, I think about a month's period of time that we're going to be able to complete what needs to be done. I do think that the agent—
I want to know the things in relation to this. Those
Yes.
other things that you put in your joint motion are not relevant. I want to know what you need to do in relation to this witness in order to complete.
Yes, and my answer is specifically to Mr. McElveen. We do need those agents listed. I do believe that they would be considered witnesses under the discovery rules. We need a copy of the acoustic sampling for any expert that we consult with. And then we're also going to be going back and finishing the deposition of Mr. McElveen. Once we have those items, then we're really going to know exactly. But I think that all of that we should be able to handle in a month's time. This issue aside, the state has been really good at arranging and getting the deposition scheduled. So we haven't had any problems with scheduling stuff with them and moving things forward.
So we're talking about, we'll need another month in order to get the actual recordings, and then a month after that in order to get everything complete in regards to this witness.
I believe so. And that's with my estimate of what I think we're going to receive with the acoustic sampling and the witnesses. That's how much time I think is a fair period of time for us to be able to complete things. I don't know if Ms. Kawas has something to add on that, though.
Judge, just because most things on our schedule have been scheduled around this case, a lot of my other cases, the judges are aware of this case because of how old it is on the priority level it's on. But I do have a case out of West Palm Beach that's scheduled on April 18th. So I'm hoping, I don't want to push this out further than necessary, but I don't want to come back for another continuance. I'm not knowing if maybe late April or May is good for everyone, or is that too late for Your Honor?
Well, I'm going to have to take a look at my calendar because I needed to know the answer to these questions first. So we're looking probably no sooner than April. But if you have a conflict, I'll take that into account when I'm taking a look at my calendar.
Thank you, Judge.
And what's available for that. So we're looking at least 2 months, February to get the recordings, March in order to do any discovery related to the recordings. And then that puts us into April. And so your trial in April, does it begin on the 18th or that week of the 18th?
Yes, Judge, it's in front of Judge Caracuzo out of West Palm Beach. It's a 2018 case that's actually on a retrial from an overturned appellate decision out of the 4th. And I don't expect it to be longer than 2 weeks, but it's set to begin on the 18th, and the client is in custody as well.
All right, so you're saying that you're unavailable from the 18th to the 29th, the last 2 weeks of April, and certainly you're not going to be wanting to do this case the week before. You're in preparation for that, correct?
No, Judge, and I think everything else I have, I will move around because Ms. Magbanua has been in custody since 2016, so I'm sure the other judges will understand. And that should be the only hiccup in my schedule. I can't speak to Mr. DeCosta's schedule.
All right, well then we're looking out probably in May. And I think we can't go any farther than that. We're just going to have to look at what weeks I can do in May. So you'll have contact from the court of the weeks that I suggest. I'll get some input from you before I send out an order to make sure that we're all clear. And but I anticipate at the earliest it would have to be in May, and I have to look at my calendar and what I've got going on to see if I can fit this in during 2 weeks in May. So I'll put that out by a separate order. I'll give some suggestions for weeks and get your input before I set those. So the motion for continuance is granted, and I will set the trial by separate order. The motions in limine that were scheduled for the next 2 days, I'm going to wait till we get closer to trial in order to schedule those in case we have any other issues that arise or they need to be amended by in any manner. So we won't have those hearings on Wednesday and Thursday either, but they'll be set. And I think we'll do it probably in the same procedure. We'll do it. We can do those by Zoom a couple weeks ahead of time of the trial. And then we'll get the trial set for 2 weeks during those months. Okay, anything else for the court? Mr. DeCosta?
Yes, Your Honor, and I think this will be helpful, and Ms. Kappelman can chime in as well, too, when the court's setting a trial date. Thankfully, we've been able to come to a number of stipulations The government has asked us to stipulate to a number of things. We've asked them to stipulate. Our stipulation alone will clear up, I believe, 3 witnesses being called. Theirs, it could be an additional 6 witnesses. So this may shave off a few days for the total trial time. I don't know if Ms. Kappelman has a better estimate of the length of the trial. That, and I will email over to Your Honors, JA, any complications that I may have in my schedule, but off the top of my head, I can't think of any trials that are going to come before this, except the one that I'll probably be trying with Ms. Kawas in West Palm now.
Okay. All right. Anything else, Ms. Kawas?
No, thank you, Your Honor.
Ms. Kappelman, anything for the court?
No, Your Honor.
All right. Okay. Thank you, everyone. We have how we're moving forward. And so you'll be getting some correspondence from my judicial assistant, and then we'll be setting it again by an order. Okay.
Understood, Judge.
All right. Thank you. We'll be in recess.
Thank you, Judge.